civil suit. That is avoided. So your lordships would avoid a meaning which defeats perhaps the intention of the legislature. Lord, now page 11. Lord, your lordships may not again read it. I'll just orally point out what my submission is. May I read, my Lord? Or
yes. Page 11.
11, para 28. Lord, the submission is that every jurisprudential doctrine may not have its foundation or basis in a statute. Lord, Lord, without reading it, I'll just orally point out what my respectful submission is. Lord, the legislature provides the letter of law.
Yes.
And your lordships, by judicial interpretation, infuse the spirit and blood in it. And that is, my Lord, the doctrinal approach. Lord, for example, doctrine of estoppel. The doctrine of legitimate expectation, nowhere to be found in any statute.
Promissory estoppel.
Promissory estoppel, my Lord. There are, my Lord, the doctrine of piercing corporate veil. It's not part of any statute. Doctrine of proportionality. It's not a part of any statute that it has the punishment or act should be proportionate to what is being dealt with. Then doctrine of causes omissus. So, my Lord, jurisprudence evolves once the letter of the law is interpreted by your lordships and your lordships infuses blood and soul in that letter of law provided. If it defeats the very intention of the act, my Lord, it cannot be accepted. Suppose there would have been a doctrine in the arbitration context which would have defeated the very object of the act. Then your lordships may, in a 5-judge combination, say that no, this doctrine is not applicable. But it furthers, my Lord, the object of the act. It supplements the intention of the legislature. So now the question is, when there is statute silence in the statute law, can the doctrinal approach be incorporated while dealing with that law? So to put it differently, when this was an argument, that when there is no reference to group of companies doctrine, can you read that into section 7 or any other provision merely as a doctrine which is evolved by judicial interpretation? Lord, there is a recent judgment of the United States, my Lord, United States Supreme Court, my Lord, and allow me to read that page 30 in arbitration. In arbitration, my Lord. Lord, therefore, my Lord, before I read it, my Lord, please examine. There are several countries broadly classified as those who have adopted the model law of UNCITRAL, those who have not adopted the model law of UNCITRAL, but all have their domestic laws, maybe fully in conformity with UNCITRAL, maybe partly in conformity with UNCITRAL, maybe completely different from UNCITRAL. Whether they can use the doctrinal approach or not, as per their domestic policy. Suppose India is UNCITRAL compliant law. Can we not have some doctrine? Lord, that is answered by the Supreme Court of United States at page 13. Lord, the citation I have given, my Lord, and I have placed, my Lord, the judgment also, my Lord, GE Energy Power Conversion Finance. Lord, para 13, my Lord, may I read this judgment, my Lord? This silence is dispositive here because nothing in the text of the convention could be read to otherwise prohibit the application of domestic equitable estoppel doctrine. Lord, please mark it. Equitable estoppel doctrine is a facet of group of companies doctrine. I'll show you. Equitable estoppel doctrines. Because I will be stopped from saying something which I did, which resulted into a defined legal relationship. Only one article of the convention addresses arbitration agreements, Article 2, and only one provision of Article 2 addresses the enforcement of those agreements. Article 2.3, the text of Article 2.3 states that courts of a contracting state, like India, Lord, India would be a contracting state in this context, shall refer the parties to arbitration when the parties to an action entered into a written agreement to attribute and one of the parties requests referral to arbitration. The provision, however, does not restrict contracting states from applying domestic law to refer parties to arbitration in other circumstances. That is, Article 2(3) provides that arbitration agreements must be enforced in certain circumstances, but it does not prevent the application of domestic laws that are more generous in enforcing arbitration agreements. Now, please mark this, my lord. Article 2(3), that is unilateral, contains no exclusionary language. It does not state that arbitration agreements shall be enforced only in the identified circumstances. Given that the convention was drafted against the backdrop of domestic law, it would be unnatural to read Article 2(3) to displace domestic doctrines in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. In absence, doctrinal approach will be available to the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. For example, Article 2(1) refers to disputes capable of settlement by arbitration, but it does not identify what disputes are arbitrable, leaving that matter to domestic law. Then, my lord, some judgment is cited. Similarly, Article 2(3) states that it does not apply fails to define those terms. Again, the convention requires courts to rely on domestic law to fill the gaps. It does not set out a comprehensive regime that displaces domestic law. Some, the only provision of the convention that addresses, dear lordships, can, my lord, 14. In sum, the only provision of the convention that addresses the enforcement of arbitration agreement is Article 2(3). We do not read the non-exclusive language of that provision to set a ceiling that tacitly precludes the use of domestic law to enforce arbitration agreement. But here one can read, my lord, doctrine. There is no exclusion by the statute. Statute could have excluded. Statute could have excluded, subject to, Lord, meeting with your lordship's test if challenged. Lord, New York Convention, my lord, I have addressed your lordships, my lord, I will not take your lordships to, my lord, that. Kindly come to page 17 directly, my lords. Some of the parameters which are considered, my lord, we have examined for your lordship's assistance, and, my lord, it would be your lordship's pleasure, my lord, whether I go into this in detail or not. I may not go to, if your lordship, my lord, feel that it might unnecessarily consume time, but the exercise is this. What are the parameters considered by other jurisdictions of the world to incorporate, to accept the group of the company doctrine? It's not just, my lord, group of the company, that somebody is a company and is group company of somebody else. That's not the only thing. Lord, please come to, my lord, page 19. Representation, agency and apparent authority. Often theories of agency and these are illustrative. These are not exhaustive. It would depend upon the fact-specific situation. Often theories of agency and representation are relied upon to bring an arbitration claim against a party who is not signatory or a part of an arbitration clause. Though the exact meaning of the agency and representation is different in each jurisdiction, the fundamental principle is that one party, acting as an agent, execute a contract on behalf of other party, which will be the principal. Then, irrespective of who the signatories are, both are liable. In this kind of scenario, questions have arisen as to whether the principal authorized the agent with categorical power to enter into and bind the principal in the arbitration clause, or the power so conferred was general authority to enter into a contract which is a substantive contract. But most of the case law is on this, that I authorize my agent to enter into a contract, but my authority can be specific, that all right, you bind me even for arbitration, or my authority may be limited, That bind me in the main substance of the contract. If there is a dispute, you two of you settle. That would be fact specific. Variety of situations have arisen under this head. If from the agreement, whether an agreement in conventional sense or an act of agreeing through correspondence or other acts, expressly confers power on the agent to bind the principal, even with regard to the arbitration generally, the doctrine is made applicable and the principal is joined in arbitration proceeding and is bound by its outcome. Now, my lord, some jurisdictions have gone a step further. There may not be any express authority, but a presumed or ostensible authority. Somebody, my lord, gives an impression that I am authorized and the principal doesn't object by his act of commission or omission. Please see, my lord. Absence of actual authority in some jurisdictions, the courts are also examining whether a party not mentioned in the arbitration clause should still be bound on the basis of apparent or ostensible authority of the party which is a party to the clause or substantive contract. In the event of a party initiating arbitration against a non-signatory or a non-party, the claimant will have to satisfy two conditions. But these are the broad conditions, my lord, which are generally found in all jurisdictions when it's a question of fastening the responsibility based on ostensible authority. A, the principal had very apparently induced by way of a false representation the claimant to believe that the agent had the authority to bind it in an arbitration clause. And B, such misrepresentation can also be implied based on the existence of undeniable and intricate business and corporate links between an ostensible principal and or the ostensible agency, which can reasonably lead the claimant to believe the existence of such an authority. This will again be a subject matter of fact situation in each case. Lord, I can skip, Lord, others. Kindly come to third party beneficiary. Lord, some jurisdictions, my lord, to how far, my lord, this court would accept again would depend upon the fact situation. But if in a contract between A and B, it is explicitly mentioned that it is for the benefit of C, and C has derived some advantage under the contract, he cannot take the plea that he is not a signatory and therefore would not be bound in the arbitration. Then party taking direct benefit. Now, I have given some judgments also. Lord, I don't think, my lord, I should read those judgments, but this is for your lordship's assistance, and we have placed, my lord, the copies of the judgment, my lord, if your lordship considers it at your lordship's, my lord, leisure to read. Then, my lord, incorporation by reference. My lord, I am not reading it, I will just generally give the overview, my lord. There are judgments, my lord, which I have cited in the footnote. Lord, in some jurisdictions, what happens is, a contract is between A and B. C is completely alien to the contract. But the contract refers that for the performance of the contract by A with regard to B, C has, by later dated so-and-so, agreed to do this. C has, by act, supplied something. C has, by his act, purchased something. So, my lords, in fact situation like this, incorporation of responsibility even by implication or reference made in the agreement with regard to a party who is not a signatory to the argument. That is also, my lord, accepted, and that is also, my lord, an extended group of company doctrine. Then your lordships may come to 24, doctrine of single economic entity. My lord, the case of discovery which my lords decide, where the registered office of the company and the subsidiary was on the same place, the chartered accountant was same, several things were being done together, one was representing other and other was representing one, my lord, respectively, etc. Then, my lord, parameters, my lord, which are, my lord, if your lordships can quickly go through 24 bottom. My lord, these are examples. Basically, my lord, as I say, my lord, these are illustrative lists, cannot be an exhaustive list, my lord. But there are several, my lord, illustrations I have given. Then, my lord, since I am not, my lord, wasting their time, my lord, I am not going into it. Equitable estoppel doctrine, single employer liability, controlled group. Lord, there are several facts which emerges before your lordships. that this is controlled by this group. This is just money going from right pocket to left pocket. Then also, my lord, it has done. Then economic realities tests, there are some judgments, my lord, on that, where group of company doctrine is applied, joint employer doctrine, etc.
Yes.
Now, my lord, what would be last, my lord, my submission? What would be the contours? My lord, suppose your lordships were to hold that as a doctrine, group of company doctrine is accepted. At the stage of section 8 or at the stage of section 11, what extent your lordship's examination would be? My lord, earlier there was a 7-judge bench judgment, that is, my lord, SBP and Company versus Patel Engineering Limited, page 32, my lord, and I have quoted.
Yes.
I am not reading it for a reason which will come subsequently, my lord. My lord, here it was, my lord, pre-amended situation. My lord, kindly, my lord, take this a little, my lord, kindly consider this. My lord, prior to the amendment, my lord, the Chief Justice of his lordships designate under section 11(6) was supposed to look at only the existence of arbitration clause, nothing beyond that. This judgment of the 7 honorable judges of this court was based on the earlier. Thereafter, the law changed. And, Lord, a little wider jurisdiction, my lord, now is available with the Honorable Chief Justice or his lordship's designate lords. Now, kindly come to para 35. After that, my lord, Vidya Trollia comes. And it says that now, in view of the amendment in the Act, namely section 11(6), this Patel Engineering is not an applicable law. It could not have said good law. It's not an applicable law because of the change of law. And, my lord, this judgment, my lord, subject to, my lord, being pointed out contrary to this, my lord, holds the field today. And I don't think, my lord, there is anything which can be objected to. This is the test laid down. Lord, it's a 3 honorable judges. Justice Khanna wrote, Lord, the majority view, and then the Honorable Chief Justice, Lord, wrote a concurring supporting. May I read, my lord, or leave it at that?
That's okay. I think we can do it.
Yes, yeah.
Yeah.
Lord, I have also, Lord, given that, my lord, and my lord, I have also said that apart from section 8 and section 11, another stage is section 60, where, my lord, this issue can be raised and can be considered. The only last argument, my lord, which is not a part of my written submissions, but in the morning, my lord, I could think of it. Please come to section 28, my lord, and I'm done. I'm not I'm not, my lord, repeating anything. 28. Lord, the group of companies doctrine has its root in equity. Because your lordships do not desire multiplicity of litigation and one-stroke dispute resolution solution under the arbitration clause. And your lordships can evolve that doctrine, that's the submission. Rules applicable to substance of dispute. Lord, please see 2. The arbitral tribunal shall decide ex equo et bono or as amiable compositor only if the parties have expressly authorized. Meaning thereby, this restriction that you cannot have any doctrinal approach is not restricting arbitral tribunal's jurisdiction, not your lordship's jurisdiction. Your lordships can say that this doctrine is the doctrine which is in furtherance of the intent of the Act. And 3, while deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable. Your lordships are also, my lord, while applying doctrinal approach, not bound by the terms of the contract.
Suppose we say that the arbitrator shall decide.
Then
what happens?
No, my lord. Then also, kindly see me. He will go by, my lord, the trade usage. That yes, in this particular trade, this is perfectly usual. Lord, really speaking, the tribunal would decide that issue, not under 28, but under 16. Under 16, whether there is an arbitration, whether we have the jurisdiction on the arbitral tribunal's jurisdiction. Here, the tribunal would be bound by your lordship's doctrine, because that's the judicially evolved doctrine, and not bound by the terms of the contract. Lord, these are my respectful submissions.
Thank you, Mr. Solicitor.
Lord, I have given, my Lord, the judgments, and, my Lord, some special which we found, my Lord, to be useful and, Lord, assisting your lordships, which is already filed. I'm not reading it. Your lordships can, my Lord, if your lordship feels, just glance through it. It would, my Lord, assist the court, my Lord, in arriving at it.
Thank you, Mr. Solicitor.
Lord, immensely grateful, my Lord, for the inquiry. Lord, would your lordship, my Lord, I'll just place, my Lord, that file.
Sorry?
The file of the law ministry, your lordship.
Not necessary, I think.
To them and thereafter.
Not necessary.
Please, your lordship.
Will be adopting the same line as the solicitor or?
Not exactly, my lord. I'll tell my lord broadly the line I'm adopting.
Your lordships can pardon my absence for some time, right?
Now, Mr. Kambata is going to argue, then Mr. Ritin Rai, right?
Yes.
That concludes everybody.
Mr. Devan is, I think, also there.
All right. How long would you take, Mr.
But I would take about 2 hours. I'll try and
About
curtail it.
2 hours.
Try and curtail it. I put my submissions.
All
in
right.
writing.
And Mr. Rai?
Lord, I've been through Mr. Kambata's submissions. I have something to add, which I've also put in my submissions, my Lord. I had anticipated, my Lord, 2 hours myself, but I'll take much less than that. Lord.
Okay.
But
So that means it will not get over today.
yes, my Lord, because I have some differences from
What
the
Mr.
other-
Kambata is
but
arguing.
even to
So today, probably Mr. Kambata will get over today.
yes,
Look,
And then then we can keep this thereafter just to keep the format and the time schedule on the 11th, because
Yes, yes.
10th is the miscellaneous
Voting
day.
day.
Next week we have 2 days which are going to be miscellaneous.
Miscellaneous.
10th will be miscellaneous. Then 11th we can take we can hear Mr. Rai for the morning session.
yes.
Morning session you can wrap up. So then we can conclude
The
the
other side.
matter by the morning session.
Tomorrow is also, my Lord, miscellaneous.
Tomorrow is miscellaneous because day after is a holiday. So.
We're grateful, my Lord. The break is a bit unfortunate because it breaks the continuity. for
Yeah, absolutely.
We're grateful.
So,
So
generally, it is said, my Lord, that never give lawyers an overnight to think. The arguments are always lengthened.
which is why it's good everyone's put it in writing.
But Alison, you got your compilation and your written submissions also.
We filed it.
So then you can just take us to navigate us.
I will do that.
We'll come back at last.